Today we're talking about torts, and we're going to look at three areas of torts particularly today. First, intentional torts, then negligence, which is unintentional torts, and then strict liability, which relates to products liability. What is a tort? A tort is a wrongful act that causes injury to a person or damage to property. Torts are different from criminal law, different from crimes. There are some similarities. For instance, we'll talk about intent. When we discuss intentional torts, we'll talk about assault and battery, which there are crimes of assault and battery. However, crimes and torts are two different things. Torts are a civil cause of action, meaning we're in civil court, we're dealing with the lower burden of proof, a preponderance of the evidence, as opposed to being in criminal court where we have to prove a case beyond a reasonable doubt. There are some similarities, but torts are separate and different from crimes. The types of damages or money award that we might see in a tort case are compensatory damages and punitive damages. Compensatory damages are damages that are designed to compensate, to make the plaintiff whole for a loss that he or she has experienced. So, for instance, medical bills, damage to property, the cost to repair it, lost wages. Those things would be examples of compensatory damages, also pain and suffering, things like that. Punitive damages, on the other hand, are designed to punish. Say that a drug manufacturer has mismarketed a drug where they've hidden information about a side effect, and as a result a number of people take it and get sick. They might sue the drug maker for negligence or product liability, and if a jury or judge found that the action by the drug company was so terrible that it needs to be punished, that we need to discourage the drug company and other companies from doing things like that, then they could potentially award punitive damages, which are designed to punish. So first we're going to look at intentional torts. Just like it says, an intentional tort is a tort that is intentionally committed. You intended to do it. And going along with that is this concept of transferred intent, which basically says that even if I intend to harm one individual but inadvertently end up harming a different person, I can still be liable to that different person, that second victim, for an intentional tort. For instance, if I was swinging a baseball bat and I was trying to hit the person standing in front of me, but they moved out of the way and the bat happened to strike you instead, the court would say, well, my intent simply transferred to you, and you could then sue me for battery. Which takes us to the first intentional torts that we'll talk about, assault and battery. The intentional tort of assault occurs when you place someone in fear of immediate physical harm. So there's no actual physical contact with assault, but you're placing someone in fear of physical contact or physical harm. Maybe you could think of an angry person getting in your face and raising their fist as if they're going to punch you. That might be assault. Battery, on the other hand, there's unlawful contact. For instance, that angry person that's in your face, if they take that fist and strike you with it, then at that point they've committed the tort of battery. False imprisonment and arrest. This intentional tort occurs when somebody is detained. Their freedom of movement is restricted without cause or without justification. Typically where this might come up in the tort context is in a shopping situation where a merchant maybe believes that you have shoplifted or something and they might try to detain you. In Tennessee, we have a statute that governs merchant's privilege, and it says they have the right to detain somebody for a reasonable period of time if they reasonably believe that you have essentially taken something, or that you've attempted to shoplift or are shoplifting. So what we have to look at is, did they have that reasonable belief? Did they detain you for a reasonable period of time? And did they use reasonable means to detain you? Intentional infliction of emotional distress. In order for someone to succeed in claiming this intentional tort, they have to show that there was some kind of extreme, outrageous behavior or conduct. And they're going to have to present medical evidence to support their claim that they've suffered emotional distress. So there have to be some medical records, maybe a physician or a mental health counselor come in and testify. Another tort that can come up in the intentional context is that of defamation. And here I would differentiate between slander, which is oral defamation, and libel, which is defamation in writing. There are three requirements that have to be proven in a defamation case. You would have to show that the defendant made a false statement, that the statement was overheard, published to at least one other person other than the plaintiff, and third, that there was some harm to the plaintiff's reputation. But if you are a public figure, a celebrity, a politician, somebody who's kind of put themselves out there in the public eye, then there's a fourth requirement. You have to show that the defendant acted with actual malice, that they actually intended to harm you or harm your career. And so those are the elements of defamation. So what are some defenses that might be raised in that context? Well, first, if the defendant can prove that the statement was in fact the truth, then that would be a valid defense. Defamatory statements, by their very nature, have to be false. So here is a discussion problem that we can look at that ties all these things together. I'm going to pause for a minute and let you read that. And as you read it, think about, would this company, this shop mart, be liable for defamation or false imprisonment? And what about intentional infliction of emotional distress? Okay, so hopefully you paused the recording and gave some thought to this. So what do you think? Would shop mart be liable for defamation? Did they make a defamatory statement, a false statement? Arguably, yes, they did make a false statement. The agents turned and said to her son, "Your mama's a thief." Well, we know that was false because she, in fact, had the receipt. Would that statement have harmed LaShonda's reputation? Well, arguably, yes. And then third, was the statement published? Was it overheard by somebody else? Well, obviously her son heard the statement, and it was Christmas Eve. There were crowds out shopping, so it would be reasonable to conclude that other people in the store may also have heard those statements. So it is possible that LaShonda would have a good case of defamation against ShopMart. What about false imprisonment? Did they detain her freedom of movement? Well, yes, they did detain her, but we have that merchant's privilege that allows them to detain someone as long as they do so for a reasonable period of time and in a reasonable manner. And did they act reasonably here? Well, probably not. They detained her for 45 minutes, even though she had the receipt. They never asked to see the receipt. The behavior, the statements that they made in a loud voice about her, it just seems very unreasonable behavior. And so, arguably, there may be a successful claim for false imprisonment. But what about this intentional infliction of emotional distress? Is there any extreme and outrageous conduct that you see here? You could argue that the statements that these agents made, your mama's a thief, she won't be home for Christmas, and that they said this in a loud voice, the way that they detained her, arguably that may rise to the level of extreme and outrageous. And it says here that LaShonda has suffered some distress, nausea, headaches, missed 3 weeks of work. If she can provide medical evidence to support that, then she may have a valid claim for intentional infliction of emotional distress. Our next intentional tort that we'll touch on is that of fraud. Fraud basically occurs where there's an intentional misrepresentation or concealment of a material fact. A material fact is one that is very important. That the misrepresentation or concealment is done with an intent to induce reliance, so we're trying to make somebody rely on it. Third, that justifiable reliance occurs and it results in some damages or some loss to the innocent party. The most recent example of this that I can think of is the example of Bernie Madoff, who was an investor. He managed people's money and accounts, and he made all sorts of misrepresentations about the type of return that people would get on their investment if they entrusted money to him, and he made those representations with intent that people would rely on him and would give him their money. They did in fact rely on him, justifiably so, because he was known as one of the experts in the field, and he took their money, he mismanaged it, and stole some of it, and as a result the investors were harmed. It resulted in damages. So that's an example of fraud. Interference with contractual relations. This occurs when you're intentionally persuading someone to breach a contract. So you know that this other person has a valid contract, and you go in there and intentionally induce them to breach that contract to your advantage. A couple other intentional torts: conversion, which occurs if you exercise control over someone else's personal property without their permission. And then trespass, which I'm sure you're familiar with as far as trespass to land, when you're crossing onto or using someone else's land without their permission. And then trespass to personal property, which is very similar to conversion. You're wrongfully taking or harming the personal property of another. So that's intentional torts, and now we'll move on to negligence. In a negligence case, there are 4 elements that the plaintiff has to prove. First, he has to prove that the defendant owed him a duty of reasonable care. Reasonable care is the duty that we owe to pretty much anyone around us, anyone who could foreseeably be harmed by our actions. For instance, if you're driving down Interstate 40 near Nashville, you would owe a duty of reasonable care to the people around you on the road where you're traveling, because it's foreseeable that if you drive erratically or carelessly, they may be harmed by your actions. The next element that the plaintiff has to prove is that the defendant breached that duty of reasonable care. How do we determine whether that duty was breached? Well, we look at the situation and we say, how would a reasonable person have acted in that situation? This is called the reasonable person standard. If the defendant did not act as a reasonable person would have acted under those circumstances, then a court would find that he breached his duty of reasonable care. Once that breach has been proven, the plaintiff has to prove causation. Causal connection between the defendant's negligence, the defendant's behavior, and the plaintiff's injuries. And there are 2 aspects to that. First, the plaintiff has to prove actual causation, or also called causation in fact. If an injury would not have occurred without the defendant's action, then there is causation in fact. Sometimes we refer to this as the but-for test. But for the defendant's action, the plaintiff would not have been injured. But that actual causation alone is not enough. There also has to be proximate causation. Proximate cause is also called legal causation, and it is present when there is a close enough connection between the defendant's act and the plaintiff's injury to justify holding that defendant responsible for the plaintiff's injuries. And we'll look at an example in a minute that will help flesh all of this out for you. So the last element that has to be proven is damages, that the plaintiff suffered some loss, lost earnings, medical bills, things like that. Now, what are some defenses that might be raised in a negligence case? Assumption of risk is a possibility, just saying that the plaintiff was aware of the risk and voluntarily accepted that risk. Second, that there was an intervening or superseding cause, something unforeseeable that would relieve the defendant of liability. And then the last two defenses that might be raised are comparative negligence and contributory negligence. Contributory negligence says that if the plaintiff was negligent at all, then the plaintiff cannot recover any damages from the defendant. That's a very harsh standard, and there are very few states that still use that standard. Tennessee does not use contributory negligence. Instead, they use comparative negligence, which basically says that the plaintiff's recovery is going to be reduced in proportion to the plaintiff's degree of fault. So if the plaintiff was 40% at fault for his injuries, then any award of damages that he might receive would be reduced by 40% to account for his negligence. A couple special negligence doctrines that can come into play. One is negligence per se. That occurs when someone violates a statute. For instance, if you were speeding and then were involved in an accident, you were negligent per se because you were violating a safety statute by speeding at the time that you crashed into the plaintiff's vehicle. Another special negligence doctrine is Good Samaritan statutes. Generally, we don't have a legal obligation to help anybody. We may have a moral obligation to step in and help, but the law does not impose a legal obligation. So these Good Samaritan statutes are a way to encourage people to stop and help someone if they see someone who is injured and in need of assistance. All right, so here's a discussion problem. Pause for a minute, read through this, and see if you think Ruth should be liable here for Jim's injuries. So our first question that we have to address here is, did Ruth owe Jim a duty of reasonable care? In other words, was it reasonably foreseeable that Jim, who is driving his car over a mile away, would be harmed by Ruth's actions? Well, arguably not. I think it would have been hard for Ruth to guess that someone driving a car a mile away from her location could be harmed by her actions. So probably not foreseeable that Jim could be harmed by Ruth's actions. So it's not very likely that Ruth owed Jim a duty of reasonable care. Let's also look at this from a causation perspective, because this illustrates the difference between actual causation and proximate cause. But for Ruth's failure to engage the parking brake and leave the car in neutral, Jim would not have been injured, right? because but for Ruth doing those things, the car would not have rolled down the hill. It would not have set the whole thing in process. So there is but for causation there. There is actual causation. But is there approximate causation? Probably not. The fact that the barn has dynamite that exploded, that could be a superseding or intervening cause that would break any causal connection that Ruth may have. Ruth's negligent act and Jim's injuries, they're just too much of a distance in the causal connection there to say that Ruth was proximately liable for Jim's injuries. Alright, so that's negligence, and we'll move on now to products liability. There are three main theories of recovery in a products liability case. You could claim negligence, you could claim strict liability, or you could claim breach of warranty. Today we're going to talk mostly about strict liability, and we'll save that breach of warranty discussion for later in the semester when we look at the Uniform Commercial Code. So strict liability. Strict liability is just liability without fault. And we're going to see that it applies primarily to really dangerous activities, or in the product liability context, unreasonably dangerous and defective products. Things that may have a defect in their design, in their manufacturing, or in their failing to warn, or in their marketing. In the law recently, there's really been a change, a shift from the idea of caveat emptor, which is buyer beware, to caveat venditor, which means seller beware. So this is an area where a lot of new regulation is coming in, and sellers, manufacturers are having to be very careful about the products that they produce. So what is the rationale? Why hold someone strictly liable? Why hold them liable without fault? Well, the idea is that we want to protect consumers and bystanders. Remember, we don't have a privity of contract requirement anymore, so even if you're just a bystander who happens to be injured by a product that someone else purchased, you as the bystander can still sue the manufacturer. Also, manufacturers are just in a better position to avoid losses related to their products. They're in a better position than the consumer to bear that loss because they have deeper pockets, and they're in a better position to obtain insurance.